Right, hello and welcome. I'm really pleased to welcome you all to this webinar launching the Nuffield Foundation funded report, When is a Wedding Not a Marriage? Exploring the non-legally binding ceremonies. At this afternoon's event, we'll hear from the researchers Dr. Rajnaara, Akhtar and Professor Rebecca Probert, who'll present key findings from the project and discuss their implications for policy and practice. We'll also hear responses from Professor Shazia Chowdhury, Dr. Stephanie Plywell and Professor Russell Sandberg. For those of you who are not familiar with the Nuffield Foundation, we're an independent charitable trust with a mission to advance educational opportunity and social well-being, primarily through funding rigorous empirical social research in our core programme areas of education, welfare and justice. In the case of our work in family justice, we aim to improve understanding of how the law in the family justice system works and the consequences that flow from it. Ultimately, through the research that we fund, we hope to help identify and shape the changes necessary to improve the outcomes for both individuals and society as a whole. Which brings us to the research being presented today. This research, which explores some of the inadequacy of the current law around weddings, lands at a particularly salient moment to directly inform proposals for legal reform. It's also important to consider the backdrop to the research, which was largely conducted during the height of the COVID pandemic. As well as the challenges this introduced and which the team overcame, the pandemic and the associated restrictions under which we all lived serve to highlight the importance of rituals and ceremonies that define our lives, making the case even stronger for the law to recognise the social value of these events and encourage them. I'm very pleased to introduce our chair for today's event, Professor Gillian Douglas, Emeritus Professor of Law and Executive Dean of the Dixon Poons School of Law at King's College London. Many of you will be familiar with Gillian through her distinguished career in family law and socio-legal scholarship and her broad interest in the relationship between the law and social change across the family life course. And with that, I will hand over to Gillian now.
Thank you very much, Ash. It's a real pleasure to be here and to have been asked to chair this event. And I want to begin by congratulating the research team on the work that they've done and the reports that they've produced. I don't think we could have asked for a stronger team to carry out this study, both in terms of their intimate and detailed knowledge of the fiendishly complicated law that governs getting married or having weddings, and also, of course, their expertise in understanding the cultural, ethnic and religious aspects of this topic. So we have a great report here, and we have an equally expert range of commentators who will be talking about it, and hopefully we'll have some very good discussion to follow on. Just on the point of discussion, if you would like to ask a question or make a comment, please put that into the Q&A section on Teams. Do that as we go through, and then I will do my best to pick those up when we get to the discussion phase of this event. I want to echo what Ash has just said about this study. I think as family lawyers, we think so much about how relationships end and devote so much of our time and attention to thinking about the process of ending and the consequences of ending relationships, that there really has been a bit of a dearth, particularly on the empirical side of things, in looking at how people form their relationships. And I think the body of work that this team, and together with our commentators actually, have done is really redressing that imbalance in our understanding of family relationships. And I think, as well as the particular focus on the processes in this study, which will be of immense utility to the Law Commission as they finalise their recommendations for weddings law. I think also, as I read this study, it tells us a lot about people's feelings and attitudes and approaches to their intimate relationships. And I think we sometimes, as particularly as lawyers, we get enthralled by the technical detail and lose sight of what these ceremonies actually mean to the people who are wishing to undertake them. And I think this study provides a real corrective, as well as providing a great deal of very useful hard information about how things are working. So without further ado, I will now hand over to Rajnaara and Rebecca to present an overview of the findings from their study before we then move on to our commentators. Over to you. Thank you. Rajnaara, I think you're muted. Go ahead, Rajnaara.
Okay, can you hear me? Excellent. I'm just going to share the presentation again. Right, can you now see the presentation? Yep, okay, excellent. Thank you. So I will start again. So I was just saying it gives me great pleasure to be here presenting this research with my colleague, Professor Rebecca Probert, and we have our research associate, Sharon Blake, in the background here as well. And first and foremost, I have to say that it has been an absolute pleasure to work with them on what is actually groundbreaking research. Anyone who's had a chance to read the report will just see how rich the data is that we've collected, and it obviously took a lot of time to work through that, and every moment of that was a revelation for me anyway. So we've worked on this project for the past 20 months, and it has been a revelation as far as the issue of non-legally binding marriages are concerned. Those of you who will have read the report in advance of this session will no doubt recognise that our findings challenge how we conceptualise a non-legally binding wedding. And we've also made it clear that there are definite arguments in favour of law reform in the area of weddings law. Over the last couple of decades, certainly, if not longer, it's clear that the way in which people wish to marry has changed significantly, and the law simply does not accommodate that reality at the moment. So in our presentation, Rebecca and I will be providing an overview of the research we conducted and some of our findings. It was a very large-scale empirical study, as I said, and we can't possibly cover all of that content in this presentation, and we don't intend to. So what we will provide is an overview of what we feel are the salient points in the report. So if I can begin then with an overview of the project. So this is really just to help provide some context. This project was investigating a wide range of non-legally binding wedding ceremonies in various communities. So we were looking at the question of the nature of the ceremonies, the beliefs, practices and desires of those involved, both the couples and those conducting the ceremonies. And lastly, the likely impact of the Law Commission reform proposals based on these weddings. And here we asked the participants for their views on the law reform proposals in light of their own practices and experiences. We were very much aware coming into this project that there was already a policy and academic focus on non-legally binding weddings being about Muslim religious marriages. So in this study, our investigation was much broader than that, because the issue is much broader than that. And we were looking at both religious and non-religious weddings, and this is something that hasn't been done previously. So overall, the aim was to find out who is opting for non-legally binding ceremonies, their reasons for doing so, the role of those who perform them, and the potential impact of different proposals for reform. So who did we engage in this study? We spoke to 170 participants in total, and they were divided up into celebrants, or those conducting non-legally binding ceremonies, and individual participants who had those weddings. So 82 of our participants were celebrants engaged in conducting non-legally binding ceremonies. And you will see from the list on this slide, it is a whole spectrum of different types of people. So 30 of our participants were female, 52 were male, and they're broken down into, well, I won't run through all of them now, we simply don't have time, but the biggest category of those engaged were Muslim imams, there were 31 of those, and then 23 independent celebrants. But as you can see from this slide, the issue of non-legally binding ceremonies touches every recognisable religious and belief community. For our individual participants, we conducted 83 interviews and engaged 88 individuals. Of the 83 interviews, 5 of the interviews included both pairs of the couple. And then finally, the types of ceremonies our participants had. Of the 83 wedding ceremonies, 67 had dual or multiple ceremonies, including 8 which were interfaith, and there were 16 single ceremonies, in other words, religious-only ceremonies. So this next slide provides a really good overview of the range of combinations of ceremonies the participants described when they had dual or more ceremonies. So of these, one was legally binding and the other wasn't. So the reasons for having dual ceremonies were multiple, and we will come to these later on in this presentation. But what this clearly demonstrates is the wide range of couples wishing to marry in a different way and then needing to undertake an additional ceremony in order to obtain legal recognition of that wedding. In some cases, there were 3 ceremonies, and these tended to be of mixed faith couples. So if nothing else, this slide should make it clear that the issue of non-legally binding ceremonies is in no way limited just to Muslim communities. So moving on then to our findings. I'm going to focus on those weddings where the non-legally binding ceremony occurred first, which was the case in 28 of the weddings out of the 83. The majority of these 28 couples were involved in Muslim nikah marriages. So 24 of the couples had nikah, and of these 24, 14 at the time of interview were in religious-only marriages. So the rationale for looking at these together is that many of the 14 who had a nikah only indicated that they did intend to marry legally, and so their motivations and perceptions overlapped in many ways with those who married in a nikah first and then had a legal wedding later. So keeping the focus on Muslim weddings for the time being, what were the possible reasons for the nikah being the first ceremony that was undertaken? So here, our participants described the nikah as the only valid form of ceremony to them, and therefore it was necessary for a couple to consider themselves married, and that's irrespective of the legal position that the ceremony occupied. For this reason, it was deemed to be more important in many ways than the legal wedding, and certainly distinctive in its purpose from the legal wedding, which was deemed to be important due to its consequence, but not for the ceremony itself. So one of our participants said, I could have had a civil ceremony, but that doesn't mean I'm married in terms of being Muslim. You're only married once you've had the nikah, so that's where the serious stuff is. Another key point made was that the nikah was necessary to enable the relationship. In other words, there was no intimate relationship. That was only through this marriage. This linkage between nikah and intimacy are quite important for some couples. Essentially, in the getting to know period, they didn't spend time alone with each other at all. And this means that the getting to know actually happened after the religious wedding. Therefore, the nikah is crucial, and its lack of legal recognition in some ways enables some couples to begin a journey towards a legally binding ceremony. Of course, it should be said this was not the case for all of the Muslim participants in this study, but it was the case for a sizable number. And also a point to note is for those of other faith groups, similar reasons were put forward as to the importance of the religious ceremony. So again, not limited to this group of participants. Looking then at imams. So while the couple spoke of their need for the nikah, the imams we spoke to also had a clear reason for performing these non-legally binding weddings. So they spoke of performing an important role in their communities where the nikah and marriage itself was part of religion, and therefore they were duty bound to facilitate it. The majority of the imams told us that they did have a conversation with the couple about the legal impact of the nikah ceremony, and they did encourage them to legally marry. In fact, some of the mosques require the civil wedding to occur first, or at least want to see evidence that notice to marry is in progress. There were, on the other hand, a very small number of imams who didn't view it as their role to advise on these legalities. So of these couples, again, there were a range of reasons why participants delayed the legal wedding or decided not to have it at all. And these are expanded upon within the report. So I will just do a brief overview. So as far as delays were concerned, a lot of these were put down to legal or administrative barriers faced by the couple. One of the big issues was COVID, and the timing of our study means that that's not surprising. So the impact of COVID was the availability of appointments to marry were few, and some participants at the beginning of 2021 certainly were telling us that they were on waiting lists trying to get this appointment. Others had their nikah, and then the legal wedding became a low priority as they were able to actually begin their lives together. And they described this as being a case of life getting in the way, but they did intend to legally marry. And then there were some who chose a deliberate delay. And this was really to enable them to see how the relationship went and whether it worked. Now, it's important to note that the participants didn't say they were testing the relationship, but we suggest in the way in which they formulated their response that perhaps that's what was happening. And as mentioned earlier, the way in which couples get to know each other varied, and for some, there was no real getting to know until after the nikah. And even those who had the nikah, not all moved in together immediately afterwards, and some waited months before doing so. Then you have the category who decided that it did not wish to legally marry at all. And again, there were a range of reasons for this. So for some, there were financial considerations. This was cited by a small number of participants, including women who wanted to retain control of their finances. And this was linked to divorce processes and a perception that religious divorce is more flexible by some. This is not an unproblematic issue, which we detail in the report. It should be noted that there were also Muslim male and female participants in legally binding marriages who also cited financial security for both parties as their reasons for choosing the dual ceremony. So it really is a decision being made based on their individual circumstances and views and beliefs. There were some participants who were unable to access legal weddings at all, and this could be, for example, due to a previous marriage still being in effect or due to immigration status in the case of one couple. And then there were just those couples who simply had no desire to legally marry. And the reason ranged from having been in a previous relationship and experienced a divorce or the breakdown, or having personal beliefs around the idea of marriage. So one of the pivotal issues of concern in the area of religious-only marriages is the idea that one party, often the women, may lack knowledge about their legal status, and policy concerns have tended to focus on this issue. So our study found that the majority of participants, both those having nikah ceremonies and those conducting them, were aware of the lack of legal recognition of the nikah ceremony. So in one participant's view that I put on the slide, there is so much awareness about it, and this is perhaps unsurprising given the attention that this issue has garnered in recent years. However, a minority did view awareness as an issue. So, for example, one participant reported that even educated women, their families will tell them this is all you need, and then 10, 15, 20 years down the line, they found themselves in a difficult position. Of our participants, only one mistakenly believed she had rights as a cohabitee, while another one did not know of her legal position. And while she made efforts to legally marry, her husband's lack of cooperation and the eventual divorce did leave her in a vulnerable position with a child to care for and no legal rights from the marriage. In other words, the real issue of concern with religious-only marriages. On that note, I will hand over now to Rebecca to talk about our broader findings and those who had dual ceremonies of marriage.
Thank you, Rajnaara, and can I take the opportunity to say what a pleasure it's been working with you and Sharon on this project too. So I'm going to be focusing on why we should also be concerned about dual ceremonies, in that they indicate how the law is often not reflecting how couples want to get married or when couples regard themselves as married. Next slide, please, Rajnaara. So some couples had a non-legally binding ceremony because the current law simply made no provision for them to get married as they wished. Now, in relation to outdoor weddings, it's worth noting that at the time that our participants married, the options for getting married outside were very limited. But in the light of the recent announcement of weddings being able to take place in the outdoor areas of approved premises, it's worth noting that this really wouldn't have provided a solution for the 17 couples in our study who got married outdoors. Although 5 of those couples did get married on approved premises, 3 of them had a religious ceremony, 1 of them specifically didn't want to be married by registration officers, and the 5th would have been happy to have had a civil ceremony, but the registration officers weren't available on the date that they wanted. The other 12 couples had all got married in a place that they regarded as significant for them, rather than one that had been pre-approved for weddings. We also had a number of participants who had chosen to have non-legally binding ceremonies because they wanted to be married in a humanist ceremony or to have a ceremony conducted by an independent celebrant. And all of these would have preferred to have had that as their legally recognised wedding rather than having 2 ceremonies. When it came to interfaith couples, the position was a little bit more complicated. Their views differed as to whether they wanted a single ceremony that could blend different faiths, as opposed to having separate ceremonies to reflect their different faiths. But where they were united was in the desire for the law to recognise their different religions equally. And one, for example, would have liked the possibility for both ceremonies to be recorded on the marriage certificate to acknowledge that both have been an important part of the process of getting married. Next slide, please. Now, one thing we often hear in this area is, why don't these couples just have a simple ceremony in the register office and then go on to have the ceremony of their choice? And there are a number of good reasons why this isn't really a solution for them. So the first is a very basic one of cost and availability. So the assumption is that it's possible for couples to get married in a register office for £46. But this overlooks the fact there's been a massive contraction in the number of register offices and in the slots when those £46 ceremonies are available. So our participants generally had to choose between having a cheap ceremony on a weekday morning, often on a Tuesday, and then having the ceremony at the weekend, a few days later. Or they had to pay considerably more to have the 2 on the same day. And sometimes they paid considerably more even when they were getting married on a weekday. So we had one who paid £400 to have what she described as a basic ceremony on a Friday morning. And where the 2 events were separated by any more than a few hours, the couples really did struggle with the sense that the ceremony was not seen as the real wedding. So the middle quote here came from a humanist ceremony who talked of your grandmother asking, "Is that the real wedding, June?" When faced with a humanist ceremony. And we had one participant whose bridesmaid actually went round saying, they're already married. They got yesterday, implying this isn't the real wedding. And our couples found that difficult to cope with. Next slide, please. But our findings also illustrated how the current options work in practice. And here, I think, was the sort of real revelation for me as somebody who's worked very much on the sort of the technical details of marriage law and assumed in some cases that these were neutral options that were equally available to all. So in terms of whether the option of getting married in a registered place of worship is a solution, first of all, not all places of worship can be registered for weddings if they're not publicly accessible to all. And places of worship are very unevenly distributed for different religious groups. If you're a Muslim living in Cornwall, Devon or Somerset, your nearest registered place of worship is in Bath or Bristol. And for many other faiths, getting married in a place of worship is simply not a realistic option if the only place of worship is some distance away. And this was the position for one pagan participant in our study. There's only one pagan place of worship that's actually registered for weddings, and getting there obviously requires not just travel for the couple, but for all their family and friends as well. There's also then differences in how this option is experienced. And key factors that made a difference were, first, whether the place of worship had appointed an authorised person, or whether a civil registrar was present. And second, whether the ceremony was a Christian one. Next slide, please. Now, these quotes are all from couples getting married in a registered place of worship, all subject to exactly the same rules and having to say exactly the same words. But one of our key findings was that the prescribed words were simply invisible to Christian groups, because they were part of their own religious tradition and had been integrated into the religious service. For other groups who used different wording or expressed consent differently, the prescribed words were experienced as a separate civil ceremony. Next slide, please. And then the final option which we look at in the report is, why don't couples sort of just get married on approved premises with a separate ceremony there? And we found that this did work in some cases. There was the possibility of an independent celebrant leading the ceremony with registrars in attendance. But that, of course, is only an option if you want a ceremony that is non-religious, given that there's an explicit bar on including material that is religious in nature. We did have some examples of the civil wedding and a religious ceremony flowing seamlessly into each other with minimal separation. And again, these would have been experienced by the parties as essentially one ceremony. But we also had cases where individuals moved to a different part of the venue for their ceremony, sometimes because they wanted part of it to be outdoors. And we also had cases where the ceremony took place in the same room as the legal wedding, but there had to be a clear gap between them. And one independent celebrant in particular spoke of the evidence of the celebrant-led ceremony having to be cleared away before the registration officers would conduct the legal wedding in the same room. Next slide, please. And in other cases, there were various constraints preventing even this combination of ceremonies. So cost and available were key constraints here. One participant spoke of her friends spending £25,000 to £30,000 on their weddings, and herself opting for a very small wedding on approved premises with just 10 people, and then having a big celebration at home in her garden. Another one would have had the legal wedding on approved premises, but the registration officers weren't available. Others found constraints on what could be included even in the non-legally binding ceremony on approved premises. So 3 participants had experienced registration officers putting a bar on religious ceremonies taking place on the same day as the legal wedding, even when separated by space or time. And a number of independent celebrants also reported that there had been difficulties with registration officers when a couple wanted to have a legal wedding and a celebrant-led ceremony on approved premises. One reported losing a booking when the registrar refused to conduct the ceremony if they were involved in it. Others knew of couples who'd been told they couldn't have a celebrant at their ceremony, and some independent celebrants also gave examples of registration services placing pressure on approved premises not to allow celebrant-led ceremonies. So our findings show how even apparently neutral rules are experienced differently by different groups. Our participants considered the existing laws to be outdated, and the reform was needed to reflect the diversity of beliefs and practices in modern society. And we hope that our report provides further evidence of the need for such reform. Thank you.
Thank you very much. Thank you very much to both of you for your overview, and I love the pictures. There's some fantastic weddings going on in the background there. Let me move straight on to the first of our commentators, and that's Professor Shazia Chowdhury, who is Professor of Law and the Geoffrey Hackney Tutorial Fellow at Wadham College, Oxford. She's an academic bencher and Associate Academic Fellow of the Inner Temple. Over to you, Shazia.
Thanks very much, Gillian. And I'd like to start also by congratulating all the authors, and it's absolutely fascinating piece of research and really, really interesting to read. So thank you so much for doing the research in the first place. There clearly is a huge need for more research in this area, I think, and the amount of detail in the report is just is really impressive. So I just want to start with the congratulations, and also thank you for inviting me to talk about the aspects of the report which relate to Muslim marriages. I mean, I think the conclusions that I was first I was very glad to see that you were covering all faiths and also humanists, etc. So that was very good to see, because as the report points out, there's been a kind of a sort of disproportionate, I think, interest in Muslim marriages when we come to look at non-legally recognised, or I can't remember the wording now, that you use in the report. So it's good to see that's recognised in the report too. And to some extent, I think what's really interesting about the report is it dispels some of the myths around Muslim marriages as well. So we see actually that there's quite a lot of positivity around religious marriages in relation to the Muslim faith, and that is very much borne out by the qualitative research included in it. So, as you say at the beginning of the report, there's a kind of inherently problematic, or religious marriages are seen as inherently problematic by quite a few people out there, and I think this is very much undermined really by the research that's included in the report. So we see actually there's lots of positive associations around religious marriages, and particularly for those of the Muslim faith towards it. But we also see some concerning aspects. So I was particularly interested to see, again, evidence, I suppose, of a disproportionate interest, or if I'm going to be really controversial, perhaps indications of a disproportionate level of scrutiny in relation to Muslim marriages. So we see imams talking about the deterrence being an issue. So although it's really positive that quite a few of the imams in your report were saying that they encouraged and in fact required in some cases civil marriages to take place before the nikah ceremony, actually what was underneath that for some of them was actually the worry, the concern that there was a sort of a higher level of scrutiny being applied to them as members of their faith who were capable of carrying out these marriages. So that was kind of quite concerning to see, and I guess I'm not very surprised to see that either. It was also really interesting to look at, again, the differences, I suppose, the slight differences between those of the Muslim faith and the rest of the people that you interviewed in terms of the lack of cohabitation. I think I'm right in correct in that nobody from the Muslim faith had cohabited prior to the nikah marriage in your report. I think there might have been a mixed faith marriage where that might have occurred, but where it wasn't. And so that, again, is probably not a huge surprise for those of us who know much about the faith. It's a hugely important factor. And that, again, was really interesting in terms of signifying what marriage really is to those members of the Muslim faith as well, which is it very much is about, as you say in the report, a recognition that this is the real marriage, and this allows intimacy being, you know, a crucial part of the Islamic faith, that this is something that you don't enter into unless you are actually married religiously, so to speak. And I think also what was interesting to me was the concept of, and this is discussed quite a lot in terms of places of worship and the need for authorisation of places of worship, which you very, I think, robustly analysed in terms of the Law Commission's proposals as well. And I think the evidence here is pretty clear that, you know, in general, I think it's probably not a good idea. But for me in particular, I think what spoke to me was this sort of aspect of requiring mosques as a place of worship. And I think that's particularly problematic when it comes to members of the Muslim faith. It's not really a place of worship as we know in the way that perhaps a church would be. It's more of a community, I think, environment in my case. I think I see it very much as that. But also we know that, you know, who goes to mosques very much depends upon that particular community, that particular culture of that particular mosque, and how you worship as well, whether you worship together, whether men and women worship together. So it's a very different proposition as well. So I thought that was particularly interesting, something that spoke to me quite a bit when I was reading through it, or made me think about it anyway. I also thought what was another important factor was the role that imams were playing, and I wondered, it was one of my questions to you actually, which I should ask now actually, was the role of imams as gatekeepers. You mentioned that in the report, in contrast, I think, with the registrar's role. So if we want to move to a system where we are authorising the individual rather than the place of worship or the place where the marriage will take place, this is something that's going to be quite important, because if there's this aspect of gatekeeping that occurs that seems to be different to other people of faith who conduct these ceremonies, that's something that's quite important. So I was kind of quite perturbed if I listened to this. So this sort of gatekeeping aspect to imams and the kind of differential attitudes towards consent that were noted in the report as well. So, for example, some imams were very happy to take the consent of the father of the woman. Some imams weren't. And I think that aspect is something that probably needs to be looked at as well if we're looking at individuals being authorised as opposed to the place of worship. And then I just had a question. I mean, you did touch on this in terms of talking about religious divorce in relation to the Muslim faith as well, and how that actually played out. And it was interesting to me to see that there was somebody who was particularly active, and that she was a woman. She was a woman who was conducting these marriages, and she was quite active, and she's called interventionist. I would say she was probably doing her job very well, actually. She took it very seriously, and she was advising mainly the women about you know, the aspects of the religious ceremony, how much they should expect to get in terms of the mahr and that aspect, and actually talking to them about, perhaps it seemed to me, implying that the differences between the sort of civil ceremony and the legal obligations that flow from that as opposed to the religious obligations. So that was quite interesting, the sort of gender differences there between the imams. And obviously I realised you had a small sample, you couldn't explore that, but I think that was potentially very interesting for future research in terms of, is there a difference in gender when it comes to those who are conducting ceremonies in the Muslim faith? Just made me think of that. And then finally, one question that I found in my mind when I was reading was, are imams advising about the consequences of divorce in Islamic law? So we talked quite a bit, the imams are talking very much about, some of them recognise the differences in terms of legal obligations of going through a civil ceremony as opposed to having a religious ceremony alone. But I wondered whether they were actually then going on to make that additional move and talking about the differences between the obligations that flow from an Islamic only ceremony, as opposed to an Islamic ceremony plus a civil ceremony too. So what's the role there the imams are playing? I'd be really interested to know that for future reference. Are they incorporating that in their role when they are playing the role of the spiritual advisor or the person who's going to do the ceremony? So in some cases they were quite active, and I thought it was very interesting. They were really clear, sometimes perhaps for negative reasons, that they wanted a civil ceremony to occur. Some of them were obviously very active in terms of trying to protect particularly the woman in the ceremony. But I wondered whether that extended actually to their role also in terms of the Islamic contract of marriage. You know, is that part of their role? Because some of them said that they didn't feel comfortable or didn't want to be in a position where they were effectively advocating for a secular system. And I think that came across in some of the other faiths as well that I read through the report. And it made me wonder whether, well, if that's fine, if you don't want to do the secular, but are you doing the religious contract? Are you explaining that to potential spouses? So if you're not going to have a civil ceremony, or in fact you are, what's the additional protection or the only protection that you have under the Islamic marriage contract? Now, I'm no expert on Islamic law, but I do know that the Islamic contract of marriage does provide financially in the event of the marriage breakdown, and that's some terms and conditions that you can agree beforehand, the parties can agree beforehand. So I was wondering how much that was relevant really to the imams, and obviously something perhaps to think about for the future. But all in all, I just thought it was a brilliant piece of work, and really, really interesting. Yeah, I think that's my comments on it really.
Thanks very much, Shazia, and I'll bring in your questions at the end.
Yeah, sure.
Let me move on then to our second speaker, and this is Professor Stephanie Pywell, who is Professor of Law and Social Justice at the Open University and Senior Fellow of the Higher Education Academy. And her current research is very much focused on marriage and wedding celebrancy, and she's worked particularly with Rebecca on aspects of this subject. Over to you, Stephanie.
Thank you, Gillian. Good afternoon, everybody. It's an enormous privilege to have been asked to respond to this final report on the excellent and exciting research project. And it's important because it provides really good, solid evidence that the Christian-originated laws that govern weddings in England and Wales are now inappropriate for the multicultural society that we live in. And it's exciting because of the depth and richness of the findings. And the report offers a real insight into practices that, as it describes, are not illegal but non-legal, and that they've therefore not been known about, and they've been ignored or widely misunderstood by society in general, and of course by some well-intentioned policymakers in particular. So I'm going to focus on the way the report deals with celebrants who are accredited by Humanist UK, who share a non-religious belief system, and with independent celebrants who, as their name suggests, have no central accrediting body, although many of them do have links with professional organisations or training providers. The report notes that several unsuccessful attempts have been made over the last 10 years or so to allow humanist celebrants to conduct legally binding wedding ceremonies. And as far as I'm aware, this study is only the second academic research project in which any accredited humanist celebrants have taken part. Just 10 of the 287 celebrants who responded to a survey that I conducted in 2020 mentioned humanist beliefs. And of those 10, 6 also claimed to have pagan or religious or spiritual or sacred beliefs. Now, my survey was almost entirely quantitative, and this study complements its findings with in-depth qualitative contributions from the 5 self-identified humanist celebrants. My survey was also the first research on independent celebrancy, and again this report complements it because the findings are based on contributions from 23 independent celebrants. Now, Humanist UK and many independent celebrants use the word weddings to describe what they do, and that concerns me a bit, but the report states that both groups inform couples that their ceremonies aren't legally recognised. One humanist celebrant has reported that she always explains to couples that she couldn't use the words marry, marriage or I pronounce you. And an independent celebrant said that being absolutely transparent and upfront with our couples is a critical part of the role. And this accords with the Professional Standards for Couples Ceremonies that's published by the Wedding Celebrancy Commission. And that's an umbrella organisation that represents and supports celebrants. And those standards require celebrants to inform all couples clearly that the ceremony conducted does not create a legally binding marriage. And all of that is reassuring because, as we've heard, it's obviously really important that couples understand the consequences of their ceremonies. Both humanist and independent celebrants and those who've chosen to have ceremonies led by them felt that those ceremonies had generally been more important than the usually brief and formal or legal marriage ceremonies that many couples had also had. And that, I think, shows us that the importance to couples is determined much more by how personal and meaningful the ceremony is than by its legal outcome. And that reflects the law's failure to enable many couples to have the marriage ceremonies they'd like. And couples also want to make promises to one another in places that are meaningful to them. And for many couples, that isn't possible under the present law, although it's just changed, as Rebecca said. So the basic choice for most of the couples was register offices, religious buildings or approved premises, and a limited range of outdoor settings associated with those. But non-legally binding ceremonies can take place anywhere safe and suitable. One humanist celebrant had conducted a ceremony under an oak tree in a field belonging to one of the couple's fathers, and 3 of the independent celebrants specialised in outdoor ceremonies. Humanists who were interviewed stressed the importance of personalisation, of freedom of choice, and of their belief system being recognised as part of the wedding ceremony, and thought that there should be an element of dignity and solemnity in ceremonies. But the report makes it clear that the distinctiveness of a humanist ceremony was lost on some of the couples, and the focus group discussion that was reported on between humanist celebrants revealed a blurred line between religious and cultural content in the ceremonies. Now, that could be interpreted as making humanist ceremonies almost the same as those conducted by independent celebrants. But Humanist UK have told me they don't accept that. They said that they prefer to be compared to those who conduct belief-based or religious weddings, because they regard independent celebrants as being commercial. Now, by contrast, independent celebrants are happy to reflect the couple's religious, spiritual or secular beliefs, and to include elements from more than one religious tradition in ceremonies. One focus group mentioned that ceremonies should include some fun, and that included when, as at a recent Elvis-themed ceremony, one of the couple had been terminally ill. And the fact that so many couples request blended or themed ceremonies is further proof that the stark religious-secular dichotomy that we currently have under the law isn't appropriate for many couples. But that fun aspect isn't straightforward. The Law Commission's provisional proposals would require officiants to uphold the dignity and solemnity of marriage. So there might need, I think, to be a clear distinction between the point where the couple express their consent and sign the schedule, thereby becoming married, and some of the more unusual or personalised aspects of some ceremonies. But only 4 celebrants in my 2020 survey said that they'd require a ceremony's content to be serious informal. So if that requirement about dignity and solemnity were law, then individual officiants or nominating organisations would have to use their discretion to decide what was solemn and dignified. And that could lead to as many inconsistencies and arguably injustices as we get from the current requirement for registration officers to have to determine whether a request for a reading or a piece of music at a civil wedding is religious in nature. And of course, the person conducting the ceremony is important too. 5 of the 8 respondents who had chosen ceremonies led by independent celebrants had known the celebrant before inviting them to conduct their ceremonies. Couples who opt for weddings conducted by registrars don't usually know who's going to conduct their wedding until they arrive for the ceremony. It might be someone that they got to know slightly when they were giving notice and planning the ceremony, but it could equally be someone they've never met and with whom they just don't click. And under the Law Commission's provisional proposals, couples would, in some circumstances, be able to choose their officiants, and everything else would follow from that. One of the report's most important findings is that almost all the humanist and independent celebrants, and those who had chose to participate in the ceremonies they led, would like those ceremonies to create legally binding marriages, and that mirrors a finding from my work. The Law Commission's provisional proposals would permit both groups to become officiants. Humanist UK, like other religious and non-religious belief organisations, will be able to nominate its own officiants and be responsible for monitoring the work that they did. But independent celebrants would have to convince the General Register Office individually that they met the criteria to become officiants. And although that generally met with approval, some humanist celebrants were concerned about the Commission's provisional proposal that nominated officiants should be prohibited from making a business of officiating at weddings by elevating the making of profits above the expression of their beliefs. And one respondent pointed out that it was odd that this constraint would apply to humanist celebrants, but not to their independent counterparts. And I can see her argument because, as she said, her mortgage had to be paid. But the difficulty there is that, as I've mentioned, Humanist UK prefer to use religious rather than commercial officiants as their celebrants comparators. And above all, the report reminds us that couples need real choice. A few respondents, though not anyone who'd chosen a ceremony led by humanist or independent celebrants, had chosen a ceremony like that because they didn't want to be legally married. Some didn't want the legal commitment, some didn't approve of marriage, as Rajnaara said, and one humanist celebrant reported about a woman, not in this survey, who told him that she didn't want a legal wedding because she'd lose her widow's pension. And this report is an absolute credit to Rajnaara, Rebecca and Sharon, and it'll be a great help to the Law Commission, and with luck to lawmakers, statutory draftspersons and parliamentarians. And with more luck, it will ultimately facilitate a wider range of people, including humanist and independent celebrants, becoming marriage officiants if they wish to do so, thereby enabling far more couples to marry in a way that's meaningful to them. And this would, as one independent celebrant commented, be an absolutely massive step towards equality. And I can only agree. Thank you.
Thank you very much, Stephanie. Really interesting. Our final speaker is Professor Russell Sandberg, Professor of Law at Cardiff University. Russell's work interrogates the interaction between law and the humanities, and he's made a particular intervention in this current debate because I suppose nearly a year ago it is now, he published his book on religion and marriage law, the need for reform. So over to you, Russell. Thank you.
Thank you very much indeed, and thanks for the invitation. I'm delighted to be here as part of the launch of this first-class book completed, first-class research report rather, completed by first-class researchers into a topic which is of great importance. And it's an incredibly important report, and it's useful in that it provides the missing evidence base in relation to weddings that are not legally binding marriages. And it also must be said, it's got a fantastic title. When is a wedding not a marriage? It really gets to the crux of it. So I've been asked this evening to talk about reform and to talk about some of the findings of the report. And the necessity really of going third or last does mean there may be a little bit of repetition in what I'm about to say, but I'm going to try and pull out some of the points which struck me when reading this important piece of research. And what struck me really was it's how interesting it is that the debate has moved on during the last decade or so. The orthodox position used to be that there was nothing really wrong with marriage law. And then that perpetuated a number of myths, such as the myth of common law marriage. Now, however, it's accepted, I think, that there's a need to revisit the law on getting married. But now a number of new myths have become established about what the problems actually are. And the value of this report is that it exposes and clarifies those myths, both in terms of what the law actually is, but also, crucially, in terms of what the problem is. Because as we've been hearing, the main myth that is now prevalent is that this is an issue confined to Muslim marriages, and that religious marriages are inherently problematic and must be deterred, with the usual suggestion that that to be dealt with by criminal sanction. And what this report does is it provides the evidence to show that the issue is not as simple as that. It provides us with much new evidence that nuances our understanding of both the current practice and what the problem is. And it shows us, and we've seen this from the slides that have been shown, that non-legally binding weddings are conducted in both the religious and the non-religious setting. And when we're talking about the religious setting, this is not just an issue for Islam, but applies in relation to Christianity, Judaism, Hinduism, Jainism, Sikhism, in relation to paganism, in the interfaith context, and of course, as we've been hearing from Stephanie, referring to her brilliant work on this too, on humanists and independent celebrants. And it's not just that it's a variety of different groups, but also these groups are doing different things and providing different services. And so treating them as one sort of homogeneous whole or homogeneous group is inherently problematic. So one thing I found particularly interesting was there's a nice sort of contrast between the Hindu priests, who for them conducting these non-legally binding ceremonies was about ensuring that the core aspects of their religion featured. Compare and contrast that with the Catholic priests, who were conducting same-sex ceremonies and were insistent that that didn't that the whole purpose of that was to sort of get around the doctrines of their faith. And I'd never, up until reading this report, thought about non-legally binding marriages in relation to Catholic priests blessing same-sex unions. And so what this report does, it really does show us how broad and important the issue is. And it also underscores that for many, for some at least, having a non-religious binding wedding is a choice. It substantiates claims found in earlier research that in some religious traditions, a religious marriage takes place so that a couple can be together without being chaperoned. And we've already heard this in relation to the finding in the report that none of the Muslim interviewees who were marrying another Muslim cohabited before the ceremony. However, the report also underlines that for many, a non-legally binding wedding is an inconvenience caused by the inflexibility of the current law. A number of people had the two ceremonies on the same day, and a number more would have wanted them on the same day if they could have had them. And the report ably shows that the current law was shaped for Christians. And it's possible to go further and to say that it's shaped upon the understanding that a religious wedding is the norm. And that's not simply the case now. And that's simply not an assumption which stands up in 2022. Moreover, the current law is not even fit for purpose in terms of religious weddings. The report points out the difficulties concerning whether a place can be registered and the number of places that are registered. And we've already heard the fact that for pagans, there's a choice of just for one registered place of worship in the whole of England and Wales. The report also highlights very, very clearly, I think this is a major finding really, how problematic the requirement to have approved words is in many religious contexts, and how these words have become part of the Christian tradition. But in a Hindu wedding, which was mentioned, it was described their inclusion felt, and I quote, really chunky and awkward, with the ceremony basically stopping for the legal bit. It's also clear from the report that the current law breeds confusion in terms of who can be approved persons and whether authorization as such would then mean that the person would be compelled to marry anyone, to conduct the wedding of anyone. And there was also concerns about the burden of administration, and that's something which I think needs to be kept in mind when we consider reform. So this report nuances the debate about weddings that are not legally binding marriages. And as its conclusion points out, it shows us that the reasons for not having a legally binding marriage first, and indeed at all, are varied. So it nuances and complicates the picture in relation to the problem. However, what does remain clear and simple is that there is a desperate need for reform. Marriage law is clearly out of date. There are all sorts of weddings that people have which cannot be legally binding marriages. The law is confused, confusing, and overly rigid. And it indirectly discriminates against some religions and excludes non-religious forms of belief and independent celebrants. This report underlines that reform is necessary. It also underlines that reform cannot and should not seek to outlaw or criminalise all non-legally binding weddings. It highlights that non-legally binding weddings are only problematic when they do not result from the free choice of the parties. But the fact that the rigidness of the current law makes the choice for them, in many cases, necessitates the need for reform. And this supports the approach of the Law Commission, at least in its consultation paper, which is all we've got to go on at the moment. And that report showed a proposed move from a buildings focus to an efficient focus system. This report shows that that would make a real difference. It could include all religions, regardless of whether they have buildings. It could include belief organisations. It could include independent celebrants. It would open up the choice of a legally binding marriage without penalising those that choose not to. And what's also clear from this report is that the Commission's proposed new role of an officiant would provide clarity on what this involves and would be particularly welcome in some traditions whose position is that there is no celebrant needed for conducting a marriage. The report also highlights that the Commission's proposal to remove prescribed words would clearly make a difference. As an authorised person in a Buddhist place of worship stated, and I quote, "It dignifies our wedding." The report validates the Commission's officiant-based approach. It highlights that a key factor in determining whether or not a legally binding wedding came first was the stance of the person conducting the ceremony. And this, I think, underscores that the training of officiants will be key if the Law Commission scheme is taken up. So the report is to be welcomed as further support for the need for a comprehensive reform of the type being considered now by the Law Commission. And as we've already heard yesterday, it was announced that the COVID prompted temporary allowance of outdoor weddings and public and civil partnerships is now to be made permanent following the public consultation. This is a welcome but limited change. It will only apply to civil ceremonies on approved premises and only now also to religious marriages already recognised by the law. And there's a key sentence in the report which is particularly important given yesterday's announcement. And it says, the desire to be married outdoors is not just about being outside a building, but about particular locations which are important to the couple. And that, I think, is the crux of the matter. We need a law on marriage which reflects the choices people are already making. In the press release that accompanied yesterday's announcement, Justice Minister Tom Pursglove claimed, and I quote, "These reforms will allow couples to hold more personalised ceremonies." I think that overstates the reform announced yesterday. But that is clearly what we need. That is clearly what the Law Commission is proposing in its consultation document. And this report highlights the extent to which that is needed. The law does not currently allow people to get legally married in the way that many want to do so. And that is the main reason why some weddings are not marriages. And so this excellent report provides evidence that we need to ensure that the Law Commission's report, as it comes out in July, is acted upon. Thank you very much.
Thank you, Russell, and that takes us on very nicely to considering where the Law Commission go next. But I'm going to open up the discussion more broadly. We have some questions that have been published. I'm going to take those first and then go on to the particular points that Shazia raised as queries for Rajnaara and Rebecca. But our questions come from Professor Sophie Gilliat-Ray at Cardiff University. Hello, Sophie. Nice to see you again. And Sophie asks, first of all, how did you identify the imams to take part in the study? And secondly, to what extent do you think the Register Our Marriage campaign has been effective in encouraging legally binding Muslim marriages? So first of all, how did you identify your imams?
Thank you, Gillian. Rebecca, if I take the first question, do you want to take the second one? Yeah, okay. So our sampling was done using snowball technique. So we had multiple entry points into Muslim communities, and we used a variety of different techniques, including social media calls, using contacts within our advisory group, using both known contacts and more cold contacts through things like Facebook and Twitter and I think Instagram as well. So we really did cast the net very wide. And then it was up to the imams themselves whether or not they wanted to volunteer to participate. There was an element of purposive sampling because we needed to ensure that we covered every different community that was visibly present within the broader Muslim communities. So there, towards the end of our engagement with imams, we were looking to fill the gaps, and that was where we went out and tried to recruit specific imams from specific communities. So I mean, I guess the other thing to note is 31 imams is probably the largest study, the largest number of imams engaged in a study of this type. So the data in particular from imams is very rich.
Thank you, Rebecca.
So obviously I don't want to sort of judge the efficacy of the Register Our Marriage campaign because we haven't sort of done a study of the position before and after that campaign. But I think it's worth noting that a significant number of mosques remain unregistered. We haven't seen a huge increase in mosques becoming registered places of worship. We also found that a lot of the imams weren't aware of the possibility of being authorised persons. And we had some who were so enthusiastic when they found out from the information we'd given them that was a possibility. You know, we had one saying, wow, you know, so we can do this. Why has nobody told us that we could do this? And I think there's also a problem with the narrative of registration, and that leads to confusion as to what is necessary for a legally recognised wedding. We had one imam in the study who insisted that, you know, he would only do a nikah if the couple had registered their wedding first. But by that, he meant giving notice to the register office of their intention to get married. Now, if all you have is intention given to the register office and then a nikah, then that couple are potentially vulnerable if they don't go on to have the legal wedding as well. So I'm sure the Register Our Marriage campaign has done, you know, lots of good things, but I think it hasn't necessarily reached all corners of the community, and I do have problems with that narrative of registration.
Particularly since it may lead to a confusion between notice and actual registration. Yeah, thank you. Let me capture the points that I think Shazia was asking, and I think broadly, Shazia, you were raising the question about the role of imams within marriage. Well, do you want to come back in and ask yourself rather than
if I can remember. Yeah, so I suppose it was broadly the role that imams play. So I was particularly interested and I was struck by that gatekeeper finding that you had, and maybe you could expand on that. I don't know. And also my question was about their roles in general. So clearly they don't play a secular role, and some people felt uncomfortable with that. And that wasn't obviously just the Muslim participants, was it? It was also other faith leaders in other religions as well. And you can kind of see why that would happen, obviously. It might be seen as a conflict, etc. But it made me wonder, well, then, you know, in your role, do you also then advise, which I would have thought they should be doing, but maybe I'm wrong and I have high expectations, but I would have thought they should be advising, therefore, on all aspects of the Islamic marriage contract. Or am I wrong? I don't know. As I say, I'm not an expert on it. And I think, I can't remember what the other question was actually.
about gender.
Yes, and gender. Thank you, Gillian, for that prompt. Yes, so there was obviously just one participant that you referred to who was, there were two women who conducted Islamic marriages, that's right, yes. And one of them was really proactive. And I just wondered if you could expand on whether that was that a gender thing? Was it just that, you know, did you have some male imams who were also a bit more kind of cognizant of their, well, the power that they had in that situation, actually, to help and, you know, to help the women, I guess, in those scenarios.
Right, thank you. Shazia, there's a lot packed in there. So what I will do, Rebecca, if it's okay with you, I'll tackle some of it, and then obviously if you want to add layers on top, plenty of scope for that. I remember that you picked up a point on gatekeepers, and I thought it was important to come back to that. So there was a point in the report where we analysed the way in which some imams were approaching the need for a guardian, effectively a wali, to be present at the point of the nikah. And the issue that was raised there was around how does this role translate into a new role? So, for example, the efficient role that's proposed by the Law Commission. And the reason we highlighted that was because the question of consent. So if we have identified in our report, which we have, that in some cases, and again, I should stress it was a minority of the imams who mentioned this, if in some cases women are not present to give consent and the consent is given via a third party, what does that then mean for a legally binding ceremony? Because clearly the normative, the norms within communities allow for that. They allow for a woman to give consent via a third party. But if we're then translating that into a legally binding ceremony, what does it mean for the officiant there? And clearly in that case, they both need to be present. So being aware that there are such scenarios is the key message here. And I guess the point about gatekeepers was that the imams in that situation have power. So they have the ability to say, well, I'll accept that or I won't accept that. So that was the point being made there. With regards to the contract, so again, looking at the scenario. So when the imams were speaking about marriage, they were speaking about marriage. And even when it came to the legalities around going on to have a legally binding ceremony, it tended to focus just on that. Some of them would go into detail about what that could then mean financially for the parties, should there be a breakdown in future. But there's certainly with the imams that we engaged, there wasn't a tendency to talk about the divorce from the Islamic viewpoint at that point, because it probably just would not be appropriate to be discussing that when they're happy and getting married. So it's probably less to do with shying away from the issue. I'm sure that were the couple to ask, the imams would be very forthcoming in what that then looks like from an Islamic legal perspective. But it wasn't something that was a salient feature in our data because we simply didn't ask the question. And then very briefly, the final point about gender. You're right, we only had a couple of women participants who were conducting nikah, and just for ease, we class them together within the group of imams. I guess it would be correct to say they are in a minority. There are not many women who are conducting nikah ceremonies. So those who do generally would be going out on a limb. It's not generally the done thing, I guess, and therefore people who are looking for a female to conduct the nikah are after something very specific. And certainly for the female that you identified, who comes across very strongly in our report, and the interview was fantastic. Her role is one that she's developed and made her own, and that would tend to be the case. And I have to say, actually bringing in the male imams here, we had such a spectrum. We did have, again, in the report, there was one imam who, you know, insisted on bringing the bride onto the stage where he was and the groom was, because he felt that that she had a role to play and she had to be there. And so really advocating on behalf of brides in those scenarios. And then obviously, on the other hand, you had those imams who were very respectful of community norms and those normative values, and therefore steering away from attempting to engage with the brides themselves. So again, it's very much, I think, reflective of what is the norm within those communities. But the great thing about this research, obviously, is we captured all of that.
I don't know if have I got room for one more?
No, I'm going to.
Fine.
We have another comment, in the Q&A, which I just feel we ought to raise, and I think, Rebecca, this might be one for you just to respond if appropriate. Person points out that couples who are interfaith are not represented, and it becomes incredibly complicated for them to have a kind of wedding or sequence of weddings that meets their combined faith needs. Can you comment at all any further? You touched on this in your overview. I wonder if it's worth just a final comment on that point, which is a very valid one.
Yes, absolutely. So we had, as I mentioned, we had couples who had different faiths, and a number of them had 2 ceremonies, but some of them had 3 ceremonies because they didn't want one faith ceremony to be the legal ceremony, because that created an imbalance between the different faiths. So some specifically had a civil ceremony plus 2 ceremonies for each of their faiths, so that there would be that equality between them. We also had one different faith couple who really wanted to have a combined ceremony, because they felt that that would show that a Christian and a Muslim could get married, and that would help with their families. And we also had couples who had interfaith ceremonies conducted by interfaith ministers, as much more of a blend of different religious traditions. So we do explore all of these in the report, but I completely agree with the commentator that the current law does not make these ceremonies easy.
Thanks. So I'll take one final question, which comes from Georgie, who's an independent civil celebrant. And Georgie asks, if the reform is successful, will there be a distinction between the officiant and those who ensure the couples are free to marry? Will these be 2 different roles?
So under the Law Commission's proposals, there would be legal preliminaries, and couples would go and give notice to registration officers, who would be undertaking the same legal checks that happen at present, or the Anglican preliminaries. So there is that separation between checking ability and capacity to marry and the officiant at the ceremony. Yes.
Thank you. And there's a final comment from an independent celebrant who again is making the point that there are constituencies who are not represented or catered for under the current law. I'm going to leave it there, but there is a final query which asks, will you publish your project result as a book?
We will. We actually had news today, which I haven't even shared with Rajnaara and Sharon yet, that our sort of book proposal has sort of been accepted, and Bristol University Press will hopefully be publishing this So watch this space.
Brilliant, that's great, and that will be a nice companion to Russell's book from last year. That's been fantastic. Can I thank all of our speakers and presenters for sticking so well to the time. It's a really important piece of research, and the Law Commission's work is really important. And I think something that struck me very recently as we look at the terrible events going on in Ukraine, I think I won't be the only one who will have seen videos and photographs of couples literally on the front line being married as the bombs fall around them. And that kind of brought home to me how significant and important marriage is, and the way in which one gets married, and I think we mustn't ever lose sight of what is underneath all of this law and practice. So can I thank everyone for your attendance and congratulate the researchers again on publishing such an important and valuable piece of research. Thank you, everyone. Bye.